and welcome to this third event in our series on power and accountability in tech, brought to you by the UCLA Institute for Technology, Law and Policy, a new interdisciplinary research center whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karanikolas. I'm the Executive Director of the Institute for Technology, Law and Policy. I will begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. Our event today is meant to scope the challenges and limits of regulation as a mechanism for generating accountability. That's not to say that regulation is never the answer or that there's no appropriate role for governments in helping to foster accountability, but an important part of scoping this conversation is understanding what considerations and cautions should apply to the development of new rules in order to ensure they are properly calibrated to address the problem and to minimize harmful adverse impacts. And I think that this conversation is essential. Not only is it valuable in its own right, but it's also essential to inform the remainder of our discussions around generating accountability, including tomorrow's event, which will feature 3 former data regulators. We have an outstanding panel today that I'm enormously excited for. Mark Lemley is the William H. Newcomb Professor of Law at Stanford Law School and the Director of the Stanford Program in Law, Science, and Technology. He is also a Senior Fellow at the Stanford Institute for Economic Policy Research and is affiliated faculty in the Symbolic Systems Program. His works have been cited 290 times by courts, including 15 times by the United States Supreme Court and more than 17,000 times in books and law review articles, making him one of the foremost cited legal scholars of all time. Kendra Albert is a clinical instructor at Harvard Law School and the founder and director of the Initiative for a Representative First Amendment at the Berkman Klein Center for Internet and Society. They serve on the board of the ACLU of Massachusetts and the Tor Project and provide support as a legal advisor for Hacking Hustling. Chinmay Arun is a resident fellow at the Yale Information Society Project, who has also served on the faculties of 2 of the most highly regarded law schools in India from 2010 to 2018, and was the founding director of the Center for Communication Governance at National Law University, Delhi. She's also an affiliated fellow with Berkman Klein and an alternative board member of the Global Network Initiative. Her latest paper, Facebook's Faces, considers the differential impact and differential focus of that platform on the countries in the Global South. And our moderator today, Eugene Volokh, is the Gary T. Schwartz Distinguished Professor of Law at UCLA and the author of the textbook, The First Amendment and Related Statutes, and over 45 law review articles about First Amendment law. He is also the founder and co-author of the Volokh Conspiracy, a leading legal blog. We are planning to have some time for Q&A at the end, so I would encourage folks to enter any questions they have in the chat as we go and as they come to you. I'm very excited for this panel. Over to you, Eugene. And you are muted at the moment, so
Technologically backward. Thank you very much for having me on the panel, I'm excited to have the other participants here as well. These are tremendously important topics, and it's great to have this kind of forum for kind of thoughtful communication in more than 280 characters at a shot. So I want to start us with one question from which I'm sure we will depart lots of.
Eugene, can you speak slightly louder?
Oh, almost nobody ever asked me that. I want to start with one big picture question that I'm sure we'll depart from in various ways. So people have long been concerned about economic power being leveraged into political power. Those have been mostly liberal/left people, but conservative people and moderate people have also been concerned about that. So on the one hand, we do have a free market system and a private property system in which private entities, including really large ones, are entitled to do what they like with their property, their money, and the like. But at the same time, people have long worried about what that might mean for democracy when that power is used for political purposes. This has been a mainstay of debates, of course, about campaign finance. The court, for example, has said that corporations do have a First Amendment right to speak about candidates, even spending a good deal of money about it, although there was a 5-4 decision with the 4 liberal dissenters being, I think, embraced by many in the media and many in the academy. So my question is, should we worry about this with regard to the big tech giants that have tremendous assets and tremendous, both tremendous amount of money, but also tremendous kind of properties online that they can use in order to say, well, you folks get to speak using directly or indirectly these properties, and you folks do not. Should we? So this is Facebook. This could be Google. This could be Amazon, Apple, Twitter. Twitter is a smaller company than them, but obviously has a lot of influence. Should we be worried about that? Should we not be worried about it? If we should be worried about that, how should we act, if at all, on our worries? Is that something that we need to have some amount of regulation of? What would those regulations look like? Would they be constitutional? If we should be worried about it, but the solutions shouldn't be regulatory solutions, what should they be? So that's the question I want to pose to the panel to get things going. Shall we begin? Why don't we begin with, say, Chinmay? And we're all on a first name basis here.
Thank you. Thank you. That's such a wonderful question to begin with. I want to start by thanking the organizers for inviting me to be a part of this amazing panel. It's such an honor to be here. And yeah, to take on that very interesting question, I'm so glad you asked, because interestingly, the essay that Mike was kind enough to flog for me in the introduction, Facebook's Faces, deals with the question of Donald Trump's account and what the Facebook Oversight Board's hearing of that case and coming up with a standard for suspension of political leaders' accounts means for the legitimacy of both the Oversight Board as an institution and for Facebook's system to grapple with these questions. I think that what came out of it was that the global set of experts were on board with the idea of a particular standard, but that standard was linked specifically to the question of incitement to violence, which doesn't answer the entire spectrum of the question that you're asking. And so while they settled the question of whether a platform, they basically said that a platform is within its rights to suspend an account, perhaps even obligated to when the result is going to be incitement to violence, but that's one kind of risk. And I think that the question you ask is interesting because there are many others which are existential threats to democracy. I'm going to cheat and expand that question by saying that the threats exist not only within the United States, but that they interfere with democracies that the companies sometimes don't understand elsewhere. And that the enabling of capital, both, as you say, through the platform or potentially direct interference by the platforms, because platforms from other countries have been accused of electoral interference in the past. Also, both of these empower groups with historic access to capital. And the implications of that are that marginalized groups that have faced historic oppression, are less likely to be able to participate meaningfully in a democracy if capital has access to more of a voice in the context of elections. But I'll leave you with that. Thank you so much. I'm looking forward to hearing what the others have to say.
Very interesting, very helpful. Thanks very much. Kendra, do you want to take?
Sure. Yeah, I'll second Chinmay to say thank you to the organizers for having me. It's it's an honor to be grappling with these big questions with such thoughtful people. So I guess I'll fight the hypo for a second, and then I'll expand upon Chinmay's points about sort of how do we think about economic power. I think one thing I would say is that I think that it's sort of like in many cases in law, it all depends on how you define the terms economic versus political power. Because I think historically, even large segments of the right or within the context of the United States, non-progressive, non-leftist, folks not on the left, have been concerned about certain types of economic power when it was wielded in ways that didn't align with their interests. We can think about things like boycotts or strikes as forms of economic power in themselves, not corporate power per se. So I think that, and those are often much more heavily regulated in a sense, although obviously there are First Amendment protections for boycotts. those are heavily regulated in a way that makes them not necessarily what we would think of when we think about kind of power, political power coming from economic power. That sort of post Citizens United come to mean corporate power. But I think that it kind of gets to what the point Chinmayi made, which I think I'm gonna sort of try to distill her very large and thoughtful point into like a taxonomy, right? Which is to say that I think there are a couple different types of ways in which corporations can influence politics, right? One is the sort of more standard, Citizens United funding candidates or speaking, and well, I guess now it's three ways. But the second being, suppression or amplification of particular political views that belong to individuals. So I think, Eugene, when you were sort of suggesting that there's that platforms are, adjusting who speaks, there's sort of an explicit set of rules around what's allowed on these online platforms, and that obviously has consequences for discourse. But I think the third point, which Chinmayi was making, is also that the ways these platforms themselves work obviously have profound effects on political speech of all different types, and this can mean things like the ability to, like the ways in which these platforms may unintentionally amplify certain forms of speech. I was really struck by, I know that the Facebook leaks have been what's been getting everybody's attention recently, and I will be honest and say I'm on leave this semester, so I've been trying to stay a little bit out of that. But I was really struck by the report from the Meta team at Twitter, which is basically their fairness and machine learning team, where they basically I'm paraphrasing wildly and I'm summarizing, but one of the things they said in their recent report about Twitter's algorithmic amplification of certain accounts and certain viewpoints is they're not entirely sure why it's happening, right? That it wasn't a sort of straightforward clickbait kind of like, oh, this is an easy solution, or necessarily a privileging of particular viewpoints. It was we actually are not entirely sure what the different sort of inputs are that are resulting in this kind of amplification. And I think that in itself is really interesting, because I think it's easy to focus on the kind of ways in which speech regulation on these large online platforms is explicit, right? The Facebook oversight board, the rules, the community standards. But frankly, I think one of the much more interesting sets of questions, especially when we talk about regulation, is how do we deal with stuff where the platform itself may have no idea why, or may not fully understand the mechanisms by which particular forms of speech or particular ways of engaging on the platform are being amplified or de-amplified, subdued. And for me, that is it's a much more complex question, because I think it can be easy to read economic motives into very complex platform behavior. And I think actually Tarleton Gillespie in his book has said that the content moderation is the product that many of these platforms are selling, right? The moderation is what makes these online platforms somewhere places people want to be. And I think that's correct. But I think also what we have to confront as we think about the types of power at play here is, that we may not, no one may totally understand the types of emergent behavior that are happening on these large online ecosystems. And that in itself is much more concerning than questions of whether, Twitter should ban Donald, to me, not to everybody necessarily, whether Twitter should ban Donald Trump or suppress certain types of speech as incitement. So I guess that's my kind of, that would be kind of my response to that question.
Excellent. Thank you very much. Mark.
Yeah, so it's an interesting question. I want to start out by noting that it's not a new question, right? Exactly. The classic adage was that freedom of the press belongs to those who own one. That's been true for a long time, and it's been true for a long time in ways that substantially constrained not your ability to speak per se, but your ability to be heard. right, by any other than a small number of people. And it's not just that you needed a printing press, you needed an apparatus, you needed money, but that the people who had those communications outlets had their own set of rules. And those rules, I think, were by and large a lot more restrictive than any of the rules we see on the internet today. The vast majority of the people speaking on Twitter or Facebook would never have an opportunity to speak on ABC or CBS or in the New York Times or the Wall Street Journal. We worried about that in a world of much more limited media, especially around television. And so we experimented with things like a fairness doctrine. That said, you know what, you got to give equal time to opposing views in certain political debates. And I think we moved away from that. And I think there's a general consensus across the political spectrum in the scholarly world, right, that was probably a good idea to move away from it, right? That it was a problematic solution, even in a world where we had very narrowly constrained media outlets. But it became even more problematic because, as our moderator, Gene Volokh, noted in a very prescient early article, speech is a lot cheaper than it used to be, right? And we have many more outlets today, many more ways of communicating information, and many more people have access to those ways of communicating information than ever before at any time in history, right? And that's come, I think, with its own set of problems, and we have been grappling with those problems. Many of those problems were ones that we could sweep under the rug when large numbers of people weren't speaking, when they weren't speaking anonymously, right? When they weren't amplified in ways that that Kendra talks about that are somewhat inscrutable. What do we do about that? I think from the governmental perspective, the answer has been pretty clear that we do nothing about it. The expansion of the First Amendment during this period has made it pretty clear that the government isn't in a position to do anything about it. And also, I think that the government isn't in a position to tell private actors that they must do something about it in the vast majority of circumstances. So the question that doesn't answer Gene's question of, is this a problem? It may be it's a problem and we can't deal with it, or it's a problem that we can deal with it only in certain ways, right? I do think it is a potential problem, right? If we feel like we've gotten to a position where we've reversed the cheap speech move, right? If now, in fact, there's so much concentration that if I want to be heard, I've actually got to be on one of a few very small outlets, and those outlets have as much control as the 3 broadcasters had, 60 years ago in television. And if that's right, that's a problem. I will note that it is a problem we had and lived with, for quite a long period of time. And while it might have frustrated a number of people, right, at worst, it seems to me that we're in danger of going back to that sort of world in which there are now some chokeholds. I don't think we're anywhere near that world yet. We've got a lot more opportunities to share views as individual citizens than we ever did before. But to the extent we think it's a problem, I think there is a potential solution that is not government should regulate speech, government should tell Facebook they can't regulate speech or anything of the sort. It is to tackle the concentration of economic power that is at the heart of it, right? And then if we're worried that the inability to sort of get on Facebook if you violate their terms of use on a repeated basis silences you in a way that bothers us, the solution is to have more alternatives to Facebook, right? And I think the good thing about that is it's a good idea for reasons unrelated to speech, right? To try to deconcentrate some of these industries. And I think it's a solution to Kendra's problem as well, or at least it provides a new cast to it, right? We worry less about one algorithm being inscrutable if we have multiple different algorithms competing with each other. A, it probably gives us more information about why the algorithm is doing what it's doing, but B, it gives us alternatives if we don't like the way that particular algorithm is going. And I think it's something that, unlike direct regulation of speech, is going to likely be constitutionally permissible. Because antitrust laws have sort of been around for a long time, and most people in most circumstances don't think that breaking up even a media outlet, or as happened yesterday, the government going after a merger of book publishers creates a First Amendment problem, if what we're really trying to do is just restrict market concentration.
Got it. Very, very helpful. I wanted to follow up briefly a little bit, just since we've gotten a little bit of the First Amendment question, although of course recognizing the First Amendment's writ only runs to a small portion of the globe. So you might think, and this touches on what Mark was saying in particular towards the end. You might think there are several different approaches that could apply here. One is the approach that we take with regard to, say, phone companies, whether regulated landline monopoly companies or regulated, famously competitive cell phone companies. They can't cut off the KKK's recruiting number. They can't cut off Antifa or the Socialist Party's get out the vote, let's say, campaign. They might want to, it's their property, but they can't do it because they have to be common carriers. UPS and FedEx can't say we refuse to deliver things from this publisher or this bookstore because we think this is horrible, awful speech. Likewise, a few states, including our own California, but this was not widely accepted by other states, say large shopping malls have to allow people to come on the property and hand out leaflets. And so it's subject to content neutral time, place, and manner restrictions, but not content-based ones, including not restrictions on offensive speech. And the Supreme Court has said that's constitutionally permissible to impose that kind of requirement on platforms. On shopping malls. So even though most states don't, but some states do. California is one, New Jersey, Pennsylvania, and some measure Massachusetts, let's say. So then the second option is indeed kind of like some sort of structural revisions to the platforms. I shouldn't say structural revisions, structural changes mandated through antitrust law. And one question I wanted to ask is, and I think I know the answer, but it's important to air it, is, you don't really want to break up Facebook into 10 Facebooks, because the whole point of Facebook is that I want to be able to talk on Facebook to all my friends, not just some arbitrarily chosen 10% of my friends. So how would that go about? And what would be the basis for that? Would it involve standard antitrust enforcement, or would it require some new specialized law? Another possibility might be to try to, and I think this relates back to some of the things that Chinmay and Kendra said, try to look at the algorithms and see if there's something improper about the algorithms or too opaque. So one possibility may be disclosure of the algorithms, although maybe they're undisclosable because they are opaque even to the people who coded them. There are all these emergent properties that we can't understand. Another possibility might be to regulate the algorithms, not regulate the platforms, what speech they allow, not regulate what speech they forbid, but regulate the algorithm, saying you can't promote speech based on certain criteria. You can imagine something saying, we don't want you to promote speech based on its popularity, because that's just a way of enhancing filter bubbles, let's say. So that's a possibility. And then there may be other possibilities. So you might say, oh, platforms, we are concerned about underrepresented groups or whatever else, so we want you to deliberately promote them and deliberately restrict the speech of other groups. So there would be a wide range of this, and I'm not sure anybody on this panel is interested in that, but certainly some people have aired that concern. So is there any one of these models that seems to make particular sense, or is it something that maybe there's nothing that we can do other than just sit back and let the evolution of the technology run its course? Or maybe there's a much better model that I just haven't focused on. Let's do this in reverse order. Let me turn to Mark first.
Do I have thoughts? Boy, I have thoughts. All right, so let me try to put them in a couple of buckets. So the first is sort of like, what can we use some of these other models? Right, the common carrier model is one that's bandied about. The FedEx claim was interesting. It was news to me that FedEx can't decide not to take my stuff. I've got to go. I'm gonna go have a chat with them, because they have clearly violated that law in my personal experience in the past, if that's true. But there are clearly common carriers in the world, right, who have on whom we impose these obligations. They are usually regulated monopolies for whom we have given a franchise, right? For whom we say, you are the exclusive provider of this service, and indeed that the government insulates from competition. I don't think we are there with network platforms. I want to try very hard not to get us to that point, right? In part because I think one of the worries of just sort of throwing our hands up and saying, fine, you are the only game in town, all information must go through Facebook, and therefore you're a common carrier. One problem with that is, as we saw with all the previous common carrier rules, it entrenches the monopoly. It discourages innovation. It makes it very hard for us to get an alternative to appear. More on that in a second. The other problem, I think, from the internet's perspective is, right, that a common carrier rule as applied to content on Twitter or Facebook just makes the internet unusable. Right? It makes it flatly impossible to get anything of value out of it. There have been proposals on the Republican side to do something like this in Congress, which I refer to as the Mandate Online Receipt of Extreme Pornography, or More Porn Act, because there's plenty that is constitutionally protected speech, which I should be allowed to pass through. It's one thing to say I should be allowed to pass or forced to pass it through from one person to another person. That's another thing to say, well, it should show up on your Twitter feed, it should show up on your Facebook page, and Twitter and Facebook can't ban it. Add to that the problem that Facebook removes something like 1 to 2 billion fake accounts every year. I take it the fake accounts would have to stay, at least except in very limited circumstances, because there's a constitutional right to anonymous speech. There's a right to even sort of deceive people in various circumstances. So, I mean, I understand the impulse for a common carrier, right? It is this impulse that says, hey, wait a minute, I'm not being given a fair shake by an institution which, even though it's a private company, doesn't feel to me like a private company. It feels like a monopoly. I don't feel like I have a choice. I think could we regulate the algorithms? Maybe. The proposals I've seen in Congress to say regulate the algorithms verge on the crazy. Some go over the line past crazy. My personal favorite was the proposal that we just make algorithms are the problem. We don't want to sort of say you can't use them, but we just make algorithms optional. Right? If you go to Google or Facebook, yes, they can sort their content by algorithm, but they have to have a non-algorithmic means of providing you information. One computer scientist asked what a non-algorithmic means of providing information on Google would look like, said, quote, "I'm picturing a computer that's turned off," close quote. Now, there obviously could be better regulations of algorithms, although I wonder whether those two are going to run afoul of the First Amendment, where I am specifically regulating an algorithm in order to target and affect the speech that is produced on the social media output. So things that seem sort of better that we might try in this area. One thing we might do is we might go up a layer, right? So Eugene's idea of common carriers as applied to Facebook worries me. Where we apply common carriers, or we sort of could apply common carriers, is where we feel like there is a structural layer of the internet that everybody needs access to. So I am more troubled, for instance, by the idea that that sort of Cloudflare or other sort of intermediary providers kick off Parler than I am that one of the companies at Twitter kick off Donald Trump, because I think that's happening at a higher layer and therefore it's harder to get around. Ironically here, the parties have now switched positions on network neutrality. Right, the Democrats who've been pushing network neutrality as sort of at the structural layer for a long time are the ones who want to regulate speech at a higher layer. The Republicans who have managed to kill network neutrality at the structural layer now want to impose network neutrality at a content layer, in a sense, which is interesting to me. I do come back to antitrust. Gene is right that we don't want 10 Facebooks. That defeats some of the purpose of the network effects. But it wouldn't be crazy to imagine an interoperability regime that said we could have a bunch of different social media companies and people could use and port their data between those companies, so that the fact that we all were on one network didn't necessarily mean we all had to use and abide by the rules of one provider, just as our telephone network, where we thought for a long time, gosh, it's got to be one company because it's one network, it became increasingly clear that we could interconnect a lot of different telephone companies, as long as we have standards for interconnection and require that openness. There's a lot of complexity to be explored there, but I think it's worth doing.
Excellent, very helpful and detailed. Let me turn to Kendra.
Oh man, yeah. I mean, I'm not. I hope that my comments about the Twitter meta stuff did not suggest that I'm like very excited about any current form of algorithmic regulation that's proposed, because definitely not thrilled about that. Even some of the explainability stuff is just, I think, yeah, mark that quote from the just turn off the computer is pretty great. And I couldn't agree with that more. I think one thing that I've been thinking about a lot in terms of regulatory models is, my primary experience in this space is I've done a lot of work on FOSTA, which was the 2018 bill that amended Section 230 to remove immunity for certain types of content related to either sex trafficking or sex work, prostitution. And I think the reason I bring that up here is actually I also have had experiences where I'm not sure FedEx is treating my packages as a common carrier, but I was also thinking about the particular dynamics around the history of regulation of obscenity in the United States, and the ways in which even a lot of these kind of more traditional these regimes that are theoretically speech promoting have, I think, historically, because of the exceptions for obscenity under the First Amendment, led to the suppression of queer speech, of sex-related speech, that kind of stuff. A lot of stuff in that category, and that's pretty well documented, right? I'm not going to totally walk through the progeny of Roth versus United States, but it's and I think one thing that we need to be thoughtful and careful about, regardless of the particular regulatory mechanisms we choose, and I agree that there's, I think, a lot to be said about interoperability from a First Amendment perspective, although given the current state of First Amendment Lochnerism, I would imagine there would be First Amendment challenges to even interoperability mandates, is, for me, the way in which these regimes help or don't help people who have traditionally lacked access to communications technologies. And I think in some ways it's actually really funny to hear members of the right talk about, Parler or the impact of online platforms, intermediaries like Cloudflare, or sort of refusing service to right-wing platforms, because before there was Parler, there was Twitter, which is sex worker Twitter, which was founded by sex workers after FOSTA, and Cloudflare refused service to Twitter. They were like, well, it would create too much legal risk for us under FOSTA, and we could talk about whether that's true. But there's a long history of platforms making politically throwing politically less powerful groups under the bus in the name of either things of economic importance or to them, or just like the sort of way in which politics is or isn't playing out in their favor. And I think we can also see this in stuff like the use of sanctions, which has harmed lots of folks outside the United States who are looking to use platforms like Google, like WhatsApp, but so that is not to say that I'm endorsing any one particular mode or not that Eugene put forward, but rather I think for me, where the rubber hits the road is, okay, what does this actually do for the people who are most harmed by these current sets of platform policies? And, how does this create ways for them to engage with these with online spaces to gain access to community, to gain access to safety. And I think a lot of the sort of proposals on the table have there's a sort of phenomenon of sometimes I think looking for the keys where the light is. If folks aren't familiar with this kind of amazing apocryphal story, right? This idea that the drunk person is like looking for their keys. Someone walks up and is like, why are you're looking for your keys under the streetlight? Is this where you dropped them? And the drunk person says, no, I dropped them over there, but this is where the light is. And I worry that we're going a little bit there in terms of the interoperability stuff, which is, and this is not to actually really disagree with Mark, that I would love for the solution to be antitrust. Like, I am totally excited that for antitrust to solve all of our speech problems. But I think that fundamentally what we saw with FOSTA was the way in which a moral panic combined with a lack of care for a marginalized population resulted in like significant harm to a group of folks who are relying on online platforms for their livelihoods, their lives, their communities. And I'm not convinced that interoperability solves the particular problem of how, you know, the economic power when we're looking at those kinds of issues. So that's kind of what gives me pause, I think, about a lot of the technical, a lot of the sort of more technically focused or antitrust solutions.
Got it. Thanks very much. Chinmay.
Thank you. I'm going to pick up where Kendra left off and use it as an opportunity to introduce, and I apologize, Americans, for this, my discomfort, I think, with a pure common carriage idea, which we had to grapple with really in my country because of the whole Facebook was trying to force free basics in India. And people wanted to use common carriage because they've been reading all of your work, the work by the American theorists. So they wanted to use that to sort of push free basics back. I went through Indian jurisprudence and discovered that our basis is actually something that I like better, which is that Indian citizens should have access to the diversity of information, and that's the European model. I like that better because I think it's less passive than common carriage. Common carriage is great in terms of, you know, let all voices bloom, but for exactly the reasons that Kendra points to, I think it can lead to trouble along the way, and it can lead to trouble in context that we discussed in the previous round, which is that people just don't have the resources to make their voices heard. And so I think that in that sense, thinking of it as consciously giving people access to a diversity of information is helpful. But if I were looking at the breaking up and interoperability question, I think that it remains an interesting one, and I'm glad that you asked it, especially because of the things that Lina Khan is trying to do now, and because of questions that are being asked, not just about breaking up, but about what companies Facebook and other big tech giants are acquiring. And so if Facebook had never been allowed to acquire WhatsApp, for example, would it be as powerful a platform today, especially in other countries where WhatsApp is used widely? And so I think that it's also helpful to think of breaking up as a don't allow them to join together in the first place question, along with interoperability, because as all of you point out, network effects are something that we need to take on board. And so if there was interoperability as well as a space for people to come up with other platforms that attract different kinds of users, I think that there's a value of thinking of it as an ecosystem. But it still leaves us with the problem that you've all pointed to, which is the question of algorithms and their opacity. And Amy Kipchinsky has done some work on how trade secrets tend to protect platforms and how they use algorithms to rank content and amplify particular kinds of content. And I'll point out that even the oversight board, which is supposed to be Facebook's own creature, is struggling to get a peek inside that particular machine of rankings. I believe that the European Union is attempting to some kind of regulation, which is a risk-based regulation. I don't know how far they'll go using their new legislation, but it's promising, mainly because it would permit them to ask questions about the basis of ranking. And that would be interesting, Jean. So for example, the standard that you pointed to, right, that what if we said that algorithms shouldn't rank content based on a criteria like popularity? The trouble with algorithms is that then they might use a proxy that we may not be able to come up with, and popularity might be introduced anyway, which is why I like the EU proposition, because it identifies contexts in which there's a high risk of algorithmic use and suggests that there might be more interventionist regulation and monitoring in those contexts. And I think it's necessary because the Facebook papers pointed out, for example, that using the anger emoji was made content sort of more, it ranked that engagement with content higher than a mere like. And so it's interesting because escalating, I think, the degree of emotional reaction, which you're now allowed to signal because of the structure of the platform, means that you can make content more visible. But those are still to do with the technology and the economics of it. I think that there's another thread to this debate that's more controversial, depending on whether or not you believe in social media as propaganda machines, and ones that can be directed a particular way. And so I know that Yochai Benkler's book, for example, suggests that it mainly happens only alongside traditional media, but that may not be the case in all countries. And so if you think, for example, of what Facebook did in other countries, I know that in mine, it actively engaged politicians, got them to use its platform, taught them how to use the platform to engage voters. And then if you think of the fact that politicians are both individuals as well as regulators, it raises questions about what platforms did prior to entering various countries to sort of engage themselves in the election and to enable a particular kind of campaigning or propaganda, if you want to use a harsh word for it. And then we'd have to ask the question of how to walk this back and what the Edward Baker for the internet would look like.
I'm sorry. Yes, thank you very much. So I think now is a good time for people to start asking some questions. Michael, our host, Michael Carnicolas, asked if the panelists have any opinion on First Amendment challenges connected with compelling disclosure, either of algorithmic information or other internal data from the platforms, for instance, as a result of the compelled speech doctrine. So to what extent are the platforms entitled to say, we're not going to disclose what you want us to disclose because that is compulsion of speech? If I could just have...
Gene is probably the best position to answer that question. So why don't you, if you want to be an immoderator for a moment, you're welcome to take a shot.
Yeah, thank you. Thanks very much. That was what I was going to ask, because I was hoping I could chime in, just because I wrote an article on the law of compelled speech a couple of years ago after the court's big compelled speech decisions in Nifla v. Becerra and in Janus. And this is really an interesting and complex area of doctrine. Let's say maybe internally contradictory. It's true at times the court has said that having to convey facts is a speech compulsion, just like having to convey opinions, and just like we can't make you pledge allegiance to the flag, we can't make you disclose certain facts. There's a case in that Riley v. National Federation for the Blind, opinion by Justice Brennan. But surely they can't be right? You can be required to disclose all sorts of things, like to the taxing authorities, both state and federal, to this in response to the census. Nobody thinks, well, that's speech compulsion, so every census question should be subject to strict scrutiny. So my very tentative answer, and it's tentative because I can't say the case law fully supports it, but what seems to make sense of the law is that requiring people to disclose factual information to the government, that the government can then perhaps redisclose in various ways, is generally speaking not treated as a speech compulsion. Logically, you can imagine why it might be, but it generally isn't. So I expect that this kind of mandate would be upheld, and I think I have some lower court cases on my side, although some I've got to acknowledge are against it. So I don't think that would be the problem. It's an interesting question whether it makes sense, and it's an interesting question whether it would help, really, given, again, the complexity of some of these algorithms. But I don't think there'd be a problem. That's my point.
So let me, I want to echo that, and as Jill notes in the chat, right? We have a whole series of regulatory disclosures, right? We have, you have to tell us what ingredients are on your food, right? What chemicals are in your pesticides, what drugs are in your FDA drug, right? And we communicate all of that information. All that's compelled speech, right? There are many of those were trade secrets. There's some question as to whether compelling that disclosure is a taking of the trade secret that requires compensation. But I don't know that any court has successfully said, oh, you can't compel it because it's our factual information that's secret. So I'm with Eugene on this. My trouble with the algorithmic disclosure requirements is actually not a First Amendment concern. It's a sort of combination of two things, right? One is it may tell us much less than we think, or give us a misleading picture of what is actually going on, right? Certainly, to use Kendra's example, right? If Twitter itself can't figure out why its algorithm is doing something, communicating the information about the algorithm in ways that's useful to the government regulatory authorities is going to be very difficult. The government regulatory authorities are not going to like the answer that we don't actually know what's going on. There's a big push across the AI world for accountable or explainable algorithms. I think we might have to just get over that. If we actually want to use sort of modern algorithmic methods, right? Precisely because these things evolve in ways that are hard to learn, hard to sort of predict, except maybe with sort of black box use. A more sort of substantive policy-oriented objection is, I think, the algorithms arguably work well only if the world doesn't know why they work. That's not true of all algorithms, but it is definitely true, for instance, of the Google algorithm. Google spends an enormous amount of its time fighting search engine optimizers whose entire job is black box reverse engineer the algorithm, figure out what will get my fraudulent products higher on the list, and move it up and mess with the algorithm. And I think if we say, well, you got to tell the world, here's how you get to the top of the Google algorithm, we're going to have a not very effective algorithm.
I think I would add to say that I think this is one of the areas where there's a complicated history about how even civil society groups have engaged with this kind of question in the United States. And I'm not even talking about like NIFLA v. Becerra or like the cell phone radiation litigation in California. I'm talking in particular about tech companies, because I think First Amendment compelled speech arguments have been historically used by tech companies to resist certain types of, or to push back against certain types of required government disclosure or lack of disclosure. And I'm thinking in particular about the context of national security letters, and also in particular, Twitter's lawsuit regarding transparency reporting around the number of national security letters that they've received. And I think this is something I think about a lot, and I don't have a particularly good answer to. But I do think that there has been this, how to put this, historic comfort with litigating, and I include myself in this because I've litigated a national security letter on behalf of a corporation, historic comfort with using corporate power to push back against government power in the tech space. And now I think suddenly we're kind of, there's even amongst folks who have historically been part of that, the shoe's on the other foot. And now we're like, oh, like, how do we help the regulators figure out the algorithm? So I don't think this necessarily disagrees, Eugene, with your point about like sort of the distinction between the requirement to factually disclose to regulators versus sort of more public compelled statements of the type in that existed in the pregnancy crisis centers in NIFLA. The other thing that worries me post NIFLA v. Becerra about sort of compelled speech doctrine is there's this language, and I believe, Eugene, you can totally correct me if I get this wrong. They believe it's in NIFLA, there is language sort of saying that you can't force people to share controversial or to make controversial statements. And this is particularly in the context, NIFLA is a case about abortion, right? It's a case about California requiring particular disclosures by crisis pregnancy centers about the services that they offered, and posting those disclosures very prominently. And I think that so far we've seen courts not make a ton of hay out of the idea that controversial could cover a lot of things. But I think especially as we sort of think about using these particular kinds of either disclosure or labeling tools for things that look more like speech, as opposed to things that look more like the percentage of protein or number of grams of protein that are in something. I think our compelled speech doctrine, our compelled speech in the United States, our compelled speech like framework doesn't really map super well onto that. And I think that's actually, one of the plausible explanations for NIFLA v. Becerra, other than that the Supreme Court's First Amendment jurisprudence on abortion exists off in its own separate sphere. But so my point here is to say that I think there's a couple different things going on that we need to think about when we think about compelled speech challenges. One is that historically, groups like the Electronic Frontier Foundation have been on the side of large companies when it comes to not requiring particular disclosures by particular types of regulations on what speech corporations can make about, for example, things like law enforcement requests. And the second is how we frame and how the context in which these disclosures might come matter. And I think one of them is exactly to your point, Eugene, is it public or is it to a regulator specifically? And I think that gets to Chinmayi's point about like in chat, which is like, just because you tell, the FTC what's in the Google algorithm secret sauce doesn't mean that you necessarily need to tell the world. But I think we need to, there's a lot of landmines the further you get into questions about compelling particular forms of speech. The last thing I'll say about this, because I want to hear what Chinmayi has to say, and I've already said a lot, is, this is already happening, right? It's happening in the context of trade secrets and criminal defense cases. Rebecca Wexler has a bunch of really fantastic work on this. But there's a case involving probabilistic genotyping software in New Jersey where they're trying to compel the disclosure. The defense attorneys are trying to compel the disclosure of the algorithm, right? It's the source code. But so all of us who have the pleasure of spending our time in speech land have plenty to learn from our defense attorney colleagues who are, I think, actively trying to get these kinds of disclosures already, running into problems around trade secret, running into problems around other kinds of resistance. As far as I know, we haven't really seen a ton of First Amendment arguments in that space yet, but I would not be surprised if we did.
Mine.
I was going to say carry on, Kendra, because I think you're being much more interesting than I could hope to be on this question. What I'm getting from this great conversation is that there are actually 3 levels at which this is taking place. One is sort of the level that can easily be made visible and is in theory controllable, which is the platform's own rules and specifically the choices that they make to implement the rules. Those decisions remain more opaque than they should be. And I think that that's actually low-hanging fruit in this context. And then there's a second layer, which is that what are the choices that they're making for their algorithm? And these are choices which they're making consciously. And I think that speaks to the debate that we're having right now, which is that what is the wisdom of asking them to disclose it? Who should they disclose these choices to? And then there's a third layer, which is why I think that the EU Act is interesting, which is that they don't know sometimes why their algorithm does what it does. I love Jonathan Zetrain's New Yorker piece on this, which is informational debt. You know that something produces a particular result, but you don't know how, and that means that it could come back and bite you in ways that you don't understand later. I really like Timnit Gebru's work for this reason, which is that I think that the AI space actually has a lot to say to the social media space on the ways in which we need to watch algorithms to understand what they're doing. That doesn't provide any kind of conclusive answer, but that's how I'm thinking about it right now.
So I would love to see some more questions and that we can then turn to. right now, except one which I think goes off on the Alien Tort Statute, which strikes me as a somewhat different matter. I don't see a lot. So I thought I would just briefly echo Kendra's point about context in commercial speech. Context matters tremendously, as with all things. The question is which contexts, but in particular, one can imagine distinguishing three different contexts. One is disclosure to the government, and that could be also in the context of disclosure to the court within the context of say criminal litigation, and that may be a disclosure to the other parties, but it's in the government process. Generally speaking, it's never been seen as a compelled speech problem to say you have to turn over evidence in your hands. Sometimes it's a compelled self-incrimination problem, but not a compelled speech problem. Curiously, there's one Second Circuit case in which prison guards basically threatened a prisoner into revealing crimes by his inmates. And I think the court was quite upset because it seemed like it was imposing on the prisoner in a way that exposed him to a lot of physical danger. But the way they got to that is to invalidate it is that this is an impermissible speech compulsion, which that makes it really quite strange, I think. But so there are some weird dissenting cases, but generally speaking, in the context of disclosure to the government, whether the government rediscloses it or not, that's not a compelled speech problem. A second thing is disclosing it on your own speech when it is commercial speech, like product packaging or an ad. Generally speaking, it's fine. Then there's the third question, which is what about in the context of something that is not commercial speech, which is to say not commercial advertising? So you might have to, for example, disclose something on every tweet. Here is why it is that we included this tweet. Or conversely, here's why we blocked this tweet. If you have to disclose it right there on your own speech, that's when the speech compulsion problems become most serious.
We do have a couple of interesting questions in the chat at this point.
Yes, exactly. So let me turn to Laura Fichtner, I'm not sure. On what level should regulation take place, given the regulation is usually a national endeavor, and there are many legislative differences even between democracies? And how would we ensure that legislation corresponds to citizenry under that jurisdiction? And how can users who are affected by regulation be included in the regulatory process? What alternatives are there to give power to users in these processes? Let me suggest, although maybe I'm mistaken, there are at least two questions in there. One is, how do you resolve the fact that we've got 200 countries in the world, and they may have their own views about what is suitable for their citizens, and yet the internet is an international product. And by the way, there's a little asterisk, what about subnational entities like states? But we can say that, we can bracket that if you want. A second question is, how do you make sure that whatever process you have, whether it's transnational or national, is going to be adequately responsible to the voice of the people? And of course, in some nations, the government's answer is we don't want it to be responsive, or it's responsive because we are the true leaders of the people and we know what the people want. But even in a democracy, it may be that process is not adequately responsive. So I'd love to hear what people have to say about that.
So this too is not a new problem. It's something that we have been struggling with since the early days of the internet. And you know, the early day version of the problem is, right, you've either got you fall to the lowest common denominator, and whether you think that's the most speech or the least speech is lowest, I guess depends on your perspective, right? But you either say I can say whatever is legal in my country and the world can see it, in which case lots of people get to see lots of things that other countries object to. Or you say it's illegal in my country and therefore I can ban it, in which case we ended up with the sort of most restrictive version of the national laws applying to everybody. As the internet developed, we got better and better at geolocation. Better and better at limitations. Now, that didn't prevent countries, particularly those that wanted to restrict speech, from wanting their restrictions to extend not just to their citizens, but to everyone. This is still a problem today. Europe takes very strongly the position that when we ban speech, not only should we ban it for Europeans or people who happen to be in Europe, but it should be banned for everybody. And if you have the right to be forgotten, you have the right to be forgotten in America and not just in Europe. not just on a European server and so forth. There have been a lot of jurisdictional fights around this question. I think those jurisdictional fights are less common than they used to be, precisely because countries have gotten better at regulating what their own citizens have access to on the internet. Clear examples of that are China, right, and the Great Firewall, or Iran, which will just sort of periodically kind of turn off the pipeline to the outside world. But the result has been, I think, not an unalloyed good by any stretch of the imagination. I mean, on the bright side, different countries with different views of what the internet speech rules should look like have more power to implement those rules. They can't as easily be subverted by other countries. But I think we are increasingly sort of finding what I call the splinter net in an article earlier this year, right? That is, what we've got is no longer an internet in a true global sense, but an increasingly fractured series of national internets subject to different and conflicting rules, and subject to the technology that's better and better at figuring out whether you're in those rules. That technology is not perfect. But people use VPNs to get around, but it's better than it used to be. It tracks people much more than it used to, and particularly when it's coupled with rules that say things like, we want local companies providing our internet services, right? Russia says Russian companies need to be the providers. China says Chinese companies need to be the providers. It's much easier for those governments to regulate the companies that are in their own territory than it is to regulate a foreign company like Facebook.
Others? Chinmay?
Yeah, this is a question that's very close to my heart. I agree with everything that Mark has said, and I'm going to try and stretch that a little. I think that the most, all of this is absolutely true, and it's true that states are trying to develop indigenous versions of these platforms, but they're not all successful at it. And I think that makes it interesting, because then the question is that do we say that there is any kind of obligation on a platform when it goes to another country and then is asked to do things by the sovereign government that it wouldn't necessarily do in its own country? And so I'm not talking about enforced copyright law more diligently. I'm talking about questions like delete particular kinds of political speech, the old Google China issues, which have not been resolved entirely, and which have taken on new color, because, as Mark points out, now it's possible to do sort of localized censorship. Now, I think that, since I assume that most of the audience here is from the United States, this question becomes interesting if you come from a post-colonial democracy, where people are still getting used to the idea of public conversation and to a public sphere. And suddenly this large, wealthy company comes in with a service like Google or Facebook or whatever. And it's that people are grappling with using it. Regulators are grappling with how to apply laws to it. Politicians are like, ooh, what can we do with this new platform? And at the same time, the company is sort of reaching inwards. And think of Myanmar, for example, trying to make sure that most people are online and are using it without any real idea of how the particular modalities of this platform mix with the society. And I think that raises questions for the platform also, which is that what are things that a platform should agree to do versus not agree to do in another country? Should it say that, okay, fine, if this is what we've been asked to do, sovereign country, we're going to respect it and censor political speech if that's what we're asked to do, or should they ask themselves more difficult questions?
Kendra?
I would love to pass my answer, because I would love to answer Mike's next question in chat, if that's
this is the one at the end of the chat? Sure. Yeah. So this is again Mike Nicholas, our host. Is it possible to decouple questions around the quality of regulation from those against regulation in principle? seems as though part of the points being made argues against the government's competence to regulate well, either due to the technological sophistication of how these things work or due to the tendency of politicians to grandstand and pass laws that look good superficially to their constituents but are atrocious in practice. Say it ain't so, Mike. That's me adding this here. Is it useful to distinguish?
I don't think we need to worry about anybody in the United States passing laws of any kind anytime soon. So.
Well, maybe not at the federal level, but states are still active. Many of them are all blue or all red. Is it useful to distinguish critiques of our ability to regulate well from the potential efficacy of regulation in this space?
All right, thank you. I love this question because I think it is very true what Mike points out here, which is I think there's a tendency to really hammer on the incredibly bad legislation that does absolutely get introduced or suggested in this space without necessarily like answer fundamentally, while kind of sometimes shying away from the question of like, could we do this correctly, right? Like, is there any version of this legislation that would be appropriate or workable? But I think I want to sort of, one of the things that I've learned sort of, I think on working on sort of Section 230 stuff post FOSTA is that I think that the grandstanding on the bad law, like sometimes the law is bad, not on purpose, but like it is not meant to have a nuanced, thoughtful impact, right? Like it is, I really love this idea of constructive ambiguity, which is just this idea that like, this is a very law professory thing, but like the idea that, when two parties want to pass a law, sometimes they actually don't agree on what they want as an outcome. So they pass something in the middle that makes no sense. But it's constructive. It's beneficial to both sides to be able to make a claim about what that law does that's not necessarily totally rooted in reality. And what we saw with FOSTA is that I think the actual goal of FOSTA was, I think, basically the deplatforming of sex worker adjacent and sex worker website, sex workers from the internet. And like, I'm not like, this is not me editorializing, there's a real tendency when we talk about FOSTA to say, oh, it was a law against sex trafficking. I wrote a blog post a little while ago because it was driving me absolutely up the wall anytime anyone said that, because if you actually look at the text of the law, it very clearly directly talks about prostitution. It's not just about sex trafficking. And so I think that when we saw with FOSTA was this idea that it was really beneficial to that the fact that the law was badly written and caused companies to massively overreact to what is a relatively small potential change in liability was part of the goal, right? That it wasn't, oh, we did this by accident, right? The overreaction to the potential for Section 230 liability and the potential for significant civil litigation was in fact a goal of what was happening. So this makes me kind of wonder about the way in which we talk about like technical sophistication or the tendency of politicians to grandstand, because I think that sometimes it's easy to see this as like, oh, this is posturing, but I don't think FOSTA was posturing. Well, there's certainly parts of it that are, right? I think it was also a way to pass a law that would change a huge swath of online platform behavior while seeming to do something very minor. And that's always the worry with Section 230 changes. So when we talk about regulation in practice versus like quality of regulation, I think it's kind of important to think about like, not just what does the regulation say, but what is the likely reaction of large companies to even the smallest risk of to small risks of liability associated with people on their platforms that they manifestly do not care about, right? So, part of what happened in the run-up after FOSTA is basically a number of websites shut down their, Craigslist shut down the erotic services section. There was a whole bunch of other Reddit shut down a whole bunch of subreddits. But fundamentally, I think the behavior here is probably best explained as these platforms, just the risk that was even relatively small, increased risk under Section 230 was not worth keeping sex workers on their platforms because they did not see sex workers as legitimate constituents to the project of their work. So, okay, rant about FOSTA. Point here is that the laws are not, it's not that we don't know how to do it sometimes, like how to regulate in these much more nuanced and thoughtful ways. I think oftentimes what I would consider bad quality regulation, and I challenge anybody who's actually read the text of FOSTA to explain to me how it makes sense, is about the creation of incentives that cause massive overreactions to small changes, and that's actually a goal of a lot of regulation in this space rather than a more sort of nuanced step-by-step approach. And so I think we can't think of it as like, oh, you don't, to Mark's example, right? Like, don't use algorithms. I mean, there's an example, there's a sort of theory of that that's like this legislator doesn't know what an algorithm is. There's also a theory of that that says, actually, this legislature would like there to be massive, significant changes to this entire sector of the economy, and this feels like a way to do it. And so I think we need to be cautious about assuming, I guess, ignorance for what actually could be, for lack of a better term, malice.
So I too think it's a great question. And it is absolutely worth distinguishing the two, but I also think it's worth recognizing how they feed into each other, right? So the prevalence of really bad regulatory ideas around the internet isn't something that we should ignore in asking the abstract question, is regulating the internet a good idea? Right? The fact that people are floating really terrible ideas, some of those might be the ones you pass. If you kick it to an agency and say, oh, well, the agency will just kind of look at it and do the right thing, maybe the agency is going to be better situated than Congress to do the right thing, but they may do some really dumb things too. And so, one way of kicking it, as Kendra suggests, right, this sort of idea of constructive ambiguity. I think that works in a world where we actually have someone we can kick it down the line to who is better positioned to make a logical and reasoned policy decision. I feel like that is no longer the courts, not because they aren't smart and motivated people, but because we are so enamored of the just do whatever the language of the statute says and don't look beyond it as a matter of legislative interpretation, that constructive ambiguity just sort of blows it up. Right? They will do that even when it is quite clear from the language of the statute that there was no resolution to this problem. They're still going to say, we're starting with the language and we're stopping. More generally, I think what you could say is that looking at the proposals of the regulation may give you some sense of the policy space in which good regulation is possible, right? So if we look at something like Section 230 and we say, hey, we've got agreement. Everybody wants to change Section 230. Democrats want to change Section 230. Republicans want to change Section 230. If you look at what they want, right, you'd need a lot more than constructive ambiguity here, right? Because what the Democrats mean when they say change Section 230 is regulate more speech, make sure the platforms take more stuff down. And what the Republicans mean when they say change Section 230 is make the platforms leave stuff up, apply the common carrier rule, apply the First Amendment, right? Those are contradictory goals. So I think, which is not to say we couldn't choose one. The First Amendment might impose constraints, right? But you would be choosing between contradictory or opposing goals. At other points, I think the goals aren't necessarily contradictory, but the sort of looking at the range of proposals that are being made points to the tensions that we're trying to navigate between. So Europe, for instance, in one of my favorite things, has a rule that says you can't keep data that's personal data that's posted about you. And a rule that says you must keep data that's posted about you, right? Because it turns out, right, for lots of privacy reasons, we don't want the companies to keep the data. And it turns out for lots of law enforcement reasons, we do want them to keep the data. Thinking about those in juxtaposition, we end up with navigating in this sort of kind of weird situation in which you must keep it for at least 6 months, but you cannot keep it for longer than 24 months. That's a regulatory compromise between those conflicting things, right? But the fact of the conflicting proposals, right, conflicting arguments gives you some sense of what the available space is in which there might be a compromise. And the final thing I guess I'll say is that I do think the sort of quality of the regulation we actually see proposed gives us information about whether regulation is a better alternative to the market to solving particular sets of problems, right? And the worse the regulations look, the better the market looks by comparison. My big caveat here is the one I started this panel with, right, which is that assumes a functioning market, right? It assumes that there is not kind of one company in charge of everything. And so pushing ideas that try to deconcentrate markets in various ways, I think makes the market a more attractive alternative to regulation. I think we'd be better off in a general matter with a kind of functioning market rather than regulation. Regulation locks the companies in place. It makes it harder for them to be displaced. But that presupposes that we're actually going to have competition.
Great, thanks, Chinmay.
I want to say that I love this idea of immunity as a potential truce between the two sides. I never thought of it that way. So thank you, Mark. I want to introduce, there was this great short piece by Laura DiNardis and her co-author that pointed out that the trouble with Section 230 type immunities is that it assumes that the companies will choose to protect speech, whereas what they're more likely to do is ally in ways that help with their strategic market interests. And I think that that's been true around the world. Whenever the companies have needed to retain access to markets, they have tilted towards doing things that would enable them to stay in a market, even if it involved allying with governments to censor, like I said before. Slightly more flippantly, I have to say that I'm fascinated by the platform's PR and the language that they use every time there's a threat to regulate them. And it's interesting because it's moved from the if you regulate then smaller companies can't cope to now, as Kendra and Mark were pointing to the flaws of existing legislation, saying, do you really want that? But I don't think that they've succeeded, because I think that the fact that everyone is talking about regulation is huge progress. If you think about what the space was like, say, 8 years ago. And so it's interesting to me that we're there. And it's also interesting to me to see how this will now move in sort of regulatory creep elsewhere, because, like I said, when these platforms entered countries in the majority world, they came with Section 230-esque ideas that were pitched to courts and regulators before they could even fully grasp the concept of gatekeeper liability at all. And India definitely did. Brazil also asked questions about the immunity back then. And so I'm interested to see how they'll respond to this debate and how it will translate around the world.
Great. Thanks. So a question from Corinne Carson. Does anyone think the Republicans would be endorsing these ideas once they realize it would force social media companies to host ISIS propaganda? I wanted to speak up a bit outside of my moderator role, because I actually made exactly the same, raised exactly the same question at a Federalist Society panel that I was on, I want to say 2 years ago. In fact, that I helped organize on this question. And one of the things that I flagged is if you're going to have a viewpoint neutrality rule, then at the very least, it itself has to be viewpoint neutral. So you can't say you have to allow all viewpoints, whether it's a platform or whether it's the California shopping mall rule. You have to allow all viewpoints, but not pro-terrorist viewpoints, or not racist viewpoints, or not unpatriotic viewpoints. And actually, some of the bills that I've seen have viewpoint-based exceptions, like, for example, for advocacy of self-harm or some such. Pretty clearly would make that rule unconstitutional. I will say that while I think, my guess is some in the audience was mostly conservatives and libertarians, and generally, more aligned with the Republican Party than with the Democrats, really did see that as sort of a poison pill and said, well, obviously that's not what we want. But I think others, their reaction was, well, that's part of the price we already pay for the First Amendment, right? If the government provides 501c3 status to advocacy groups, it has to provide it equally, or educational groups equally, to groups that spread awful ideas. If it provides tax exemptions alongside that to religious groups, it has to provide it to kind of jihadist Muslim groups or extremist groups of other religions, or Scientologists for that matter. And I think that at least some Republicans, their view is, if the question is, do we, for one, welcome our new robot overlords and or at least tech overlords, and in order that they can block ISIS propaganda, they get to decide what else they want to block, or say that just like the post office has to carry ISIS propaganda along other things, setting aside that which is really actually conspiring with ISIS, which is a crime, then well, that's the price we pay for the viewpoint neutrality mandates that we have. So that was my reaction from the Republicans I know, but I'd love to hear what the other panelists think.
I wish, Eugene, that I shared your sense of optimism. I will say that I think fundamentally a lot of the conservative backlash around social media censorship, I honestly view it more through the lens of like a political advocacy tool rather and legislative solutions to it as sort of ways of engaging with fundamentally like bills that they don't actually think they're going to pass that are likely to move voters or move a base. I think that in my view, what's really interesting, so that there's some really amazing research by a scholar named Oliver Hamison who did a bunch of different interviews with different people who believed that they had faced censorship online, right? And one of the interesting things and he did it with white trans people, with conservatives, and with Black anti-racist activists. And one of the interesting sort of results of this was that the research basically suggested that the white trans activists and the Black anti-racist activists were pointing out that the rules that Facebook, I think it was primarily about Facebook, had said they had were not being implemented correctly, whereas the conservative folks were upset that the rules were the rules, right? And I think that for me, I keep coming back to this because I think there's a fundamental disconnect between the reality on the ground of concerns about social media censorship amongst leftist speakers, especially sex workers, anti-racist advocates, trans folks, to the extent that trans folks are speaking and getting silenced, where they're not in a position that they expect these rules to be like they don't expect the system to benefit them. And what some of the quotes in Oliver's research suggested is that what the conservative backlash to social media censorship actually felt like it had more to do with the ways in which the online platforms were violating what conservatives felt were the norms that they would want to put forward. And so all of this, that's sort of an aside. So let me get back to the question and to Eugene's point, right? Which is to say that I don't believe that the pushback amongst conservatives on social media censorship, at least at the GOP party level, is fundamentally in good faith. And so I don't think that personally the idea that ISIS propaganda would be allowed under the rules is a downside, because I don't believe that the argument is being made in such a way as to really suggest a policy rationale. I think it's frankly, at least amongst the far right, much more of a particular form of grievance politics. That's my view.
Mark?
Uncharacteristically, I have nothing to add.
All right, let's see. Michael was asking about how data protection and privacy questions relate to this. What he says is, personally, he's much more positive towards strengthening privacy rules, but strikes him that some of the same considerations about governments passing bad or poorly thought through laws exist in that space as well. And likewise, there can be a nexus between speech and privacy, certainly when you start to branch into areas like algorithmic fairness. So I wanted to throw that out to the panel, whoever wants to start. Kendra, I think Gavin started in a while, so why don't you start?
All right. Well, I mean, contrary to the title of this panel, I'm in favor of privacy regulation in the United States. So I think that I kind of share Michael's sense that I think it would be valuable. I think there's a lot of political momentum around strengthening privacy legislation in the United States, and I think that the current status quo is like kind of pretty terrible, frankly, in my own personal view. I think that there certainly are related concerns. And I think one of them, to go back to the conversation about the sort of Twitter algorithm, is I think one of the challenges of tech regulation currently is that oftentimes the people who are the best positioned to provide input on how to effectively regulate have vast amount of experience working at large scale within corporations and are therefore either not necessarily historically interested in regulation, or there are a number of reasons, incentive-wise, why it's difficult for them to take on positions that would allow them to effectively advise on how to regulate effectively. And I think Ari Waldman has a new book where he talks really extensively about sort of his views based on interviews about privacy regulation and in companies. But I'll say, from like the folks I know who have spent time doing privacy work in large corporations, there is a fair amount of difficulty in transitioning to a role where you could effectively advise the government in how to do a good job of regulating, or even congressional staff, and teach Congress people how to legislate in these areas. So I think that like one of the things that worries me about the privacy regulation or privacy legislation discussion, and I think this relates to the conversation about speech and about crappy laws, right, is that we may have created tech companies so large that the only people who know how to regulate them are the people who work there, and that's a really a bad position to be in, because it means that those of us who haven't spent time at large, or very much time at large tech companies, are not necessarily in a good position to suggest effective strategies, but also that there are real incentives at play in who works at tech companies, large tech companies, and who spends time there, both monetary and just sort of temperamentally. And so I think that's one thing that worries me about the push for privacy regulation. And I think we've seen with the CCPA that there's a lot of difficulties, right, in doing this right. And I think there's plenty of work on how there could be better solutions in some parts of the CCPA. But I think for me, one of the concerns is sort of the knowledge that's required to do the stuff well at scale.
Excellent. Thanks very much. So I should have mentioned this before or when reading the question. We're almost out of time. We have 3 minutes left. So if the remaining panelists want to split it up as they like, I'd love to hear from you, subject to the constraint.
Chinmayi, go ahead.
You, Mark. I'll keep it short because I really want to hear what you have to say. I think that for me, I'm just going to surface the most controversial one that I've heard in this context so far, which is that some states, okay, notwithstanding that I'm in general pro-privacy and pro-privacy legislation, I think it's interesting that some states take an our people, our data approach to privacy legislation. And that's an illustration of not just of privacy washing, but of a very particular kind, which is that where we are happy with our people being treated as capital, but they're our capital, not yours. And I think that that's one dangerous one to watch out for. Some kinds of data localization laws are like that. And the second, of course, is the use of privacy language, but then what is done with it, again, is dubious for one of the reasons that I described, but for several that Kendra did. I'm going to stop here because I want to hear what Mark has to say.
So Mark, you have the last word.
All right, so I too am I am fine with appropriate privacy regulation. I think we probably don't have enough of it in the United States. Since my paper that got me here is called "The Contradictions of Platform Regulation," I will note the considerable potential tensions that exist in some of the regulatory proposals, particularly when coupled with the antitrust proposals. Right. So, for instance, right, one of the privacy things that people worry about is hey, too much data has been concentrated in too few hands. right? Google, Google knows too much about me. Facebook knows too much about me. They've collected all of this information, and that is itself a problem. The solutions to that, which may involve breaking up the companies, may involve kind of separating out the data, preventing the aggregation of data from different sources, might turn out to involve having more people having access to your data rather than less. So one particular example of that are the antitrust cases against Google and Facebook in the advertising industry, right? There's a plausible case that they have monopolized the digital advertising market. If they've done that, what they've done is raised the price of advertising based on your data and had fewer people do it, right? The antitrust solution, the economic solution to that is let's have more competition there. Let's open it up. Let's have more people have more access to your data for less money so they can market to you more effectively. That is a market answer to the problem, but it's the opposite of what I think a lot of the privacy advocates want. There are ways to navigate this. This is not the Section 230 tension. We just are irrevocably opposed to each other. There are ways to navigate it, but I think it turns out to be really important to try to think about a bunch of different moving pieces and how pulling on one of those might affect other things we care about too.
Well, excellent. I wanted to thank the panelists for their remarks. Very much appreciate your time and contribution. I wanted to thank Michael for organizing all this, and I want to thank the audience for coming and listening. And I take it there'll be some other people who'll be watching on video when this gets posted. But it's great to see. I was about to say great to see everybody's faces. I see only a very small portion of your faces, but it's great to see at least the names and the numbers.
I'll just jump in again to say thanks, everybody. This is a fantastic conversation. I hope some or all of you can join us tomorrow for a discussion on the challenges that regulators in this space face with Anne Cavoukian, formerly Information and Privacy Commissioner for Ontario, Eduardo Bertoni, formerly the inaugural Director of the National Data Protection Authority of Argentina, and Alex Albin, formerly Chief Privacy Officer for Washington State, moderated by UCLA's own Andrew Selbst. I'm really looking forward to that as well. Thanks so much to all of you. Thank you to the panelists and to Eugene as well for moderating, and have a great rest of your day.